The drill broke down.
Bill, did Casey say he was coming or not coming, or?
We didn't hear anything either way. We just heard from Dan. That was it. And then Dylan said he might be late.
We can start.
7. Yeah.
Oh, we turn the mics and start the meeting.
Let's see.
Seeing it's 7:01, we're going to call the meeting to order. Do we do a roll call first?
Kralichek,
Here.
Kirschman,
Here.
Hanson,
Here.
Bixler, Loest,
Here.
Healy,
Here.
Tacky, Cruz. Any of them online?
Seeing that we have a quorum, I guess we'll go. The first item is any additions to the agenda.
I'd like to make a comment on the John Gunnarsson application.
Is that, you're going to add that at 7:20?
Correct.
Okay, I'll add that one to 7:20. John Gunnarsson.
Well, I'd like to make a note.
I'd make a motion
for the notes last meeting.
for notes. I hear a motion. That's a motion, right, Healy?
Yes.
Yeah, I think we have to
That's
take a motion,
procedure, correct.
right? Do we have to take motions and then second it?
Are we approving the agenda?
No, not approving or any additions. Do we have to make a motion to add anything to the agenda?
The motion would be to approve the amended agenda,
Okay.
whoever makes the motion.
Okay, sorry about that.
Yep, you're good.
Anything else that we need to add or subtract to the agenda? Okay, do I have a motion to approve the new agenda?
So moved.
I need a second.
I'll second.
Okay, Kevin, second. All in favor, say aye.
Aye.
All opposed, say nay. Okay, approval of last meeting's minutes. Is there any changes or anything that?
I had a comment on there again, the John Gunnarsson application. There was only 3 people voted on that application. Is that acceptable as a quorum?
We had a quorum present at the meeting.
And is that saying that is correct procedure?
You have any, I believe that's correct procedure as
Yeah.
long as you've got a
Notice there was
quorum
only
at the
3
meeting.
people voted on it. Just raising the question. Okay.
Move to approve the previous meeting minutes.
Second? I'll second it. Hanson seconds. All in favor, say aye.
Aye.
Aye. All opposed, say nay. Motion passed. Declare any conflict or conflicts of interest.
Make sure everybody's talking into their mics there.
Oh, they're hard time hearing me? Okay. Yeah, make sure everybody turns their mics on.
Yeah, and you
Aye.
gotta get pretty close to talk to him too.
Okay, declaring any conflict of interest on the new approved agenda.
I do not.
I see none for me.
None here.
Kevin's here. Dave.
I just have some information is what I'd like to share, and that's I guess the long and short of it.
Mr. Chairman,
Yes.
I'm going to again request Mr. Liddy recuse himself from discussions on our permit. He was out for the last meeting. That's what Commissioner was.
We were able to hear the whole meeting out in the hallway, so
So
there wasn't any information that we missed.
are we fully discussing Gunderson's application again tonight?
From what was requested, I just assumed we were talking about the findings of facts. I wasn't sure why he came back.
Is that what you're asking to be done? So the item that was added for your application, then yes, I will recuse myself from findings of fact because I did at the last meeting as well.
So, Vickler, so we are doing the findings of facts like we have done in the past on all these coming forward? Or just on this, just on Gunderson's, or,
This was just a request by him.
okay,
And I'm assuming because you guys didn't walk through 309 and 310 specifically on that application is what Mr. Gunderson is asking you to do tonight. Is that clear?
Findings of fact, conclusions of law need to be approved or prepared, one or the other, and they need to have Mr. Vetter sign to make the modification of the permit in correct and due form.
Okay. So does that make sense, Frank?
yep, I just wanted to get clarification. Just because we have not been doing, on the last 3-4 meetings, we have not been doing any findings and facts, but we have done it for the last 6-7, since the beginning of 2012, there we go. Have been
Yep.
doing it, and
if you have an in-house permit, then our director up above should do the findings and facts on an in-house. When it comes down to us, then we should.
And at the last meeting, we didn't do it on Eilers because it was done before.
Yeah, because I questioned it last meeting.
You did,
yeah, I know we've.
because
questioned
we
it.
did that before and you got, the only thing that was missing from that one was the, help me with the easement. Thank you. That was the only thing missing on that one because it had been done before. So we have to be careful to say that we haven't been doing it.
So as a group, before we even start tonight, are we gonna be doing finding and facts for everyone?
Yes,
Going forward,
yes.
is that a
I don't know,
consensus?
didn't we find that to be just a redundant procedure that?
Well, for these all tie together. So in my opinion, we can go through findings of fact and apply it to each one of these. Gary, is that acceptable?
Sure.
Since it's essentially one project with 3 players, if you will. So one set of findings of fact would suffice for these 3. Does that make sense, or did you want to go through each of them
It makes sense, and I just wanted to make sure that we're doing
consistently? Absolutely.
Yeah, all the way through. If we're gonna change, we're gonna change. If we're not gonna change,
Right.
we stay the same. There is no confusion that way.
Why did we stop doing it? What was the reason? I think we just moved the meeting along a little quicker.
Yeah, because we
And,
discuss everything when we do it, but
Right,
I
right.
understand
So I
why
don't
we
know
were.
where it was, was felt it was necessary to go
Okay.
through everything again,
Okay.
I believe is why we can discontinue doing it.
Okay. So the findings of facts, I know last time, going back to Gunderson's, Sherry and Healy have excused themselves, or my thoughts are probably be the same thing as that. What
Yes, that we should remain consistent on that. As far as sitting as a board member, we should be recused.
accused? Okay,
Now, I have a question though. Has that been added to the agenda?
it's been added since for the last about year.
No, I mean, John's request.
Yes,
That's not on mine.
we just added it,
Oh.
just a minute ago. Healy added it.
It's on at 7:20.
I sent a second one out.
I guess I never.
Okay,
Yeah, I haven't
I
seen
never
that.
got that. Or I didn't
Okay.
see that one.
I guess I didn't see that one either. I
That's
guess
why I don't, that's why I questioned it.
that's why we added it to approve that.
After the packet was originally sent out, it was added, so I sent the same.
Okay.
I know you added what they wanted.
They went ahead to
But I didn't-
discussion, and so you're thinking we should have two different parts?
No, I didn't
Okay,
see it on mine.
Okay.
So I didn't-
You're good.
very good.
That's good.
Is there any other declare of conflicts of interest? Seeing none, and seeing it's 7:12 already, I guess we're gonna start with first one at 7:05. Ordell. Well, yeah, Ordell Oswald, and now these three projects are together, right? Correct? Are you gonna speak on behalf of all of them? What do you think as a board? Should we put them together or should we do them separate?
They're all tied together by pipe? And you're kind of the ramrod anyway? Okay, I have no problem. He
So-
must present them all if that's,
It's all the same family too.
Yep,
Oh,
so,
so they should have been all kind of one application, I'd say.
so it's, since we have three applications, I guess what I would suggest is we discuss them all together and then we have three motions to approve.
Okay,
And then it'll be quicker, more efficient, and then at the end, we're legally on good ground.
yep. Ordell, if you want to come up, or whoever wants to come up and speak. Oh, okay, Jason, yeah. Jason, if you want to come up and explain your project. And, state your name and I think they asked for address too.
Okay,
Is that correct?
That's,
Okay.
my name is Jason Oswald. My address is 603 East 20th Street here in Yankton. I'm looking to do a tile project here on section 12 in Jamesville Township. Basically draining that southeast quarter into what's commonly called Mud Creek. My dad has the piece to the way north, so we're going to go into that a little bit. And there's another picture that shows the tile design. You maybe have it in front of you there.
Would it help to maybe go up and point things out to us? If that's
Yep.
acceptable to the committee?
is
Yeah.
there a laser pointer?
Yeah,
for him?
if we had a laser pointer, we could use that, but
We used to.
could you just kind of show us what pieces you're talking about?
Yeah, what-
Where in general things are going, please?
So I'm Jason, this is my property. My aunt is Mary Ann Van Scoy, who lives in Missouri. She owns this 80, and my dad owns this quarter up here to the way north. And so we are going to start with tile in this piece here, and it's going to come down basically in three lines, as you can kind of see by the drainage. There's one here, there will be one here, and another one that will end up here, and all three of them will go into the creek here. This property on this side is owned by Ron Schaefer, and so I will cross his property, depending on where we end up, 20 feet or 20 yards or whatever it might be to get to the creek in that process there. But there will be three main lines with fingers off of it, as you can see on your map that you were provided.
Mud Creek, of course, is the blue line, so.
Yes, it is.
So where would you cross Ron Schaefer at possibly?
Well, if, for example, there's probably gonna be an outlet somewhere in here.
I see right
And
at the
so
creek.
this little bit, I'm technically on Ron's
Okay.
ground because the dividing line is the
Looks like Ron signed off on the project anyway, so.
Oh, I see, it shows in the plat book, there is a little slice.
Yes.
On Mud Creek, is there enough flow? I know we always been talking about flow. Is there enough flow on this already coming down for the water, capacity of the water? Once you get in mud, is it a pretty good ravine going? Or I should say.
Depends on which spring you're talking about, but yeah.
Once you outlet.
Once you outlet, yeah, there's plenty of free flow.
There's
It
plenty of flow.
drops pretty fast.
And there's plenty of capacity to
Yeah,
handle
and I think there's 3 culverts that go through the gravel road
it.
here.
Okay.
So,
Yeah, and the creek is well maintained. I mean, it's
Okay.
not silted in or anything, so it flows pretty good.
Any other questions?
Well, I was just looking, and I know there was one of these that had, oh, there it is. Okay, so your discharge lines, your main lines, what size are they? You know, off the top of your,
6, and 8.
The way north one will be a 6-inch.
Yeah.
And the next 2 bottom ones will be 8-inch.
then what are you running, 4s or 5s for laterals?
Yeah, mostly 4s.
Oh, that's much better picture than what we got.
Is that bottom one gonna outlet in the field into the creek?
Correct.
Right at the ditch?
Yeah, we're not gonna be in the ditch or in the right of way. It'll be in the field. It'll be in the field, yes.
And so basically you're following the
Looks like
normal path of
Right, I mean.
surface
You
run.
can kind of see where
Right.
mainly the water runs, and this area kind of flattens out, but we'll enter in here. We're not gonna go into the ditch or into the right of way, and, this one will be right in this area here, as you can see, and then the third one will follow.
And you got grid line doing the work, so they'll operate a few feet off of,
Correct.
won't put it right in the bottom of the trench.
No.
Yeah.
How about the next piece over? I see you're not doing anything there. No, up here, is that in the future or is that
Well,
someone else?
Some of that has already been tiled
Oh,
in
I
a
see.
previous project with Ron Schaefer, and at this
Oh, some
current
of that
time,
went
this
that
is
way.
pasture.
I see.
So,
I was just
down
curious.
the road.
Yeah, maybe, yeah.
So you got big enough mains in to handle if you decide to do that 5 years from now?
You know what Ron did on that, I can't honestly
Oh,
even
okay.
tell you what he did on.
Oh, so that would have to go with his
Looks like
direction.
that,
That
yeah.
would go this way here.
Okay.
That would have to do.
Okay,
in order
gotcha.
For this piece to drain.
Okay, gotcha.
I think that's a 6.
And I don't know what he did on his side of the fence there. He has come up with tile here, I know. But then it stopped.
Any other questions from the board?
No.
Okay, anybody else want to speak for the project? I think Jason, enough questions. Anybody else want to speak for the project? Anybody want to speak against the project, oppose the project? Seeing none, I think we'll go to board discussion. Close it and go to board discussion.
Do you want me to walk through 9 and 10?
Yeah, you might
Okay.
If you want to.
Sure will.
Now, are we gonna, I see it's 7:20 now, and then we talked about all three projects.
Mhm.
And we'll just label them all as one project then, correct? Or we're gonna do findings of facts for all three, because they're gonna all have three defined outlets, and then attach them to each permit.
I suggest we do just one set of findings of fact.
Yep.
And then 3 motions to approve
Okay.
using the same set,
Same set.
because they all of them are intertwined, so. Section 09, number 1, the flow or quantity of water to be drained will not overburden the water course.
I think we discussed that. I
And-
asked them if there was enough flow.
Okay. Number 2, drainage will not flood or adversely affect the land of the lower proprietors, or in the case of an impediment to drainage, whether such an impediment will not flood or adversely affect upstream. And letters have been sent out for all of these. No feedback was given.
Kevin,
Okay.
local up there. said
And
it
this
was
is a blue line.
Where does Mud Creek dump into? I'm not familiar with that.
Goes, yeah, hi there. It washes out my fence and then it goes down into the Jim River.
So it ends up in the gym.
Ends up in the gym.
Easements will be granted where required, and those were supplied. Drainage will not negatively affect ag productivity. And the goal here is to improve it. The land affected or the land drained is and will remain rural in character. So we're good there. The land to be drained is rural land. The resumption and factors set forth in 46A, 10A, 20 will be satisfied. And those are the state laws, of which I thought we had in here. And you know, that's in another section of our ordinance here. I'll pull those here in a second. We'll skip that one. Number 7, adequate precautions have been taken to ensure that roadways will not be negatively impacted. No roadways are affected because you're not draining into the ditch here. Recommendations from the Drainage Commission in findings of fact, such other factors the Drainage Board determines to be pertinent. So that's 9. So when we get to number 10, first one is drainage into receiving water courses which do not have sufficient capacity to handle the additional flow and quantity of water shall be considered to have an adverse effect. And from experience, as Kevin has said, that shouldn't be a problem here. Whether drainage is accomplished by reasonably improving and aiding the normal and natural system of drainage according to its reasonable carrying capacity, or in the absence of a practical natural drain, a reasonable artificial drain system is adopted. Any issues with that one? I didn't see any. The amount of water proposed to be drained is considered. The design and other physical aspects of the drain are considered. The impact of sustained flows are considered. Recommendations from the commission are recorded in findings of fact. So sustained flows, since this is an identified water course, design and other physical aspects of the drain. It doesn't seem like there's anything really unique about these drains.
The only thing we've always added is make sure they rock the outlets
For erosion control.
for erosion control. Rock the outlets for erosion control.
That's, I think that 4610A20 is to do with not adversely affecting lower downstream
Yeah, it is.
owners.
So these are the 6 guiding principles in state law. The land receiving the drainage remains rural in character. The land being drained is used in a reasonable manner. The drainage creates no unreasonable hardship or injury to the owner of the land receiving the drainage. The drainage is natural and occurs by means of a natural water course or established water course. Owner of the land being drained does not substantially alter on a permanent basis the course of flow, the amount of flow, or the time of flow from that which would occur, and no other feasible alternative drainage system is available that will produce less harm without substantially greater cost to the owner. And this is where it naturally drains anyway. So we're not changing the course, so we shouldn't be changing the amount of flow into the system. So that would be state law. So far, the only recommendations we have is to riprap, to be sure to riprap to prevent the erosion at the point of outlet. Anything else we need to include?
None that I know of.
No. Great. David?
No, looks like a good project.
Okay, I guess any other comments? I take a motion for Ordell's permit.
Also move to permit or
I'll second.
Okay, roll call vote.
Krolichek,
Aye.
Kirschenman,
Aye.
Hanson,
aye.
Loest,
Aye.
Healy.
Aye.
Okay, motion passes. I think 7:10, Mary Ann Van Swyk. Thank you. Okay, I guess we have done kind of all the comments and stuff and the findings of fact. So I guess I would take a motion to approve this application.
So moved.
I'll second it.
Roll call vote.
Krolichek,
Aye.
Kirschenman,
Aye.
Hanson,
Aye.
Loest,
Aye.
Healy.
Aye.
Motion carries. Seeing it is 7:25, we'll do Jason Oswald. I guess it's the same project, same findings of fact, so I guess I would take a motion to approve this application.
So move.
Second.
Roll call vote.
Krolichek,
Aye.
Kirschenman,
Aye.
Hanson,
Aye.
Loest,
Aye.
Healy.
Aye.
Motion carries. Okay, I guess seeing it is 7:30, I guess we can go to the 7:20, the John Gunderson's application. I guess we'd call it,
Thank you for coming.
Congratulations.
yeah,
Good luck.
All right.
it'd be the application asking for the, I want to ask for the book there. For the findings of facts. Is that the updated agenda, or how do we have it in the updated agenda? I mean,
What's it? I don't know. I don't have a copy of that. Gary, what's it say on the updated agenda? Oh, look at this. This is service with a smile. Thank you. It just says finalized permit.
finalizing permit, okay?
So
I guess,
if you need to walk through those, they're in the back of your packet.
yeah, I seen the
309,
309, 310.
Yep,
and
I'm just
then
gonna
the
step out in the
statement.
hall.
Okay, this would be, there was 2 conflicts of interest. Just
Sure.
a minute, John, here.
Sure.
Okay, John, before you stand here, I want to ask Gary Vedder. It says John Gunderson finalizing the permit. So Gary, can you explain what we are doing here to be finalizing this permit?
Basically, all we were asked was that John wanted to be back on the agenda. And he basically gave us this this in an email that he wanted to finalize the findings of facts after talking to the state's attorney. I was told we don't have any requirement to sign it or anything. We don't on any of the finding of facts, but you can certainly listen to what he wants. And if you want to approve the findings of facts as he states, that's your prerogative.
Okay, so the permit was, Gary, I have a quick question here.
Yes.
We approved the permit last meeting.
Correct.
And the permit was given to him, but he wanted to find the findings of facts to be added to the permit?
Correct.
Okay. Any other questions?
Well, we used to always, after the meeting ended, we signed papers. We used to always sign papers that how we
Always voted, right?
we voted on it, and we haven't done that for quite a while now. I wondered why we haven't been.
I think the interim director had changed when he came.
Yeah, when the when Gary came in, he decided,
Prior to that,
and the county commission.
when,
Okay, I just wondered if that was a criteria that we needed to be.
Yeah, once I started, it was kind of discussed that the meeting was that they didn't want to be discussed in the meetings, and it kind of went that direction. And so I guess the few meetings we've had, we didn't do it since. So, but we have no issue doing that and here in the future.
Well, I mean,
But-
would that have answered any questions that we voted on it and had it done with?
But, you know, I've heard a lot of different things about what might have been done in the past or is done now, but you know, even and signing them and everything else, I guess I haven't seen that on the server that there was anything like that, but.
Did he get a permit? Because you always go in the office, get a signed permit, says this is permit number
Well, remember,
111-11.
this was the approval of the modification. He got of his original permit way back in August.
Right.
And so that was signed and
Okay.
dated and numbered and everything else. So
Okay. I just wanted
this was just for the modification.
to clarify what we're doing here. Any other questions, Kevin? I guess you weren't here last time.
I wasn't here. I was at the prior one.
Okay. Anson, any other questions?
No, let's go forth.
Okay, John, Gunderson application, state your name and address and.
Very briefly, John Gunderson, Irene, South Dakota, 57037. What you have in front of you is a combination of some documents that were prepared by our lawyer in consultation with the state's attorney. The reason we're doing this is that we had a modification of the original permit and permit 20-015. So if we don't have, right now, if you went up and searched that permit, it would show the outlet in a different section. And what we need to have is a recognition, legal recognition, that modification has been approved. Now, I'm going to let my daughter explain why she thinks it's important, and I agree with her, although I don't know exactly what she's going to say.
We can let you come back up, John.
I want to thank the committee for the opportunity to speak.
Sorry about
Okay,
that.
sorry.
Go ahead and state your name.
Annika Gunderson, currently living in Vermillion, South Dakota.
Okay.
I want to thank you for the opportunity to speak. I really hope this is the last time we have to discuss this permit. It's the third meeting now. JHGAS Farms has seen what happens when we don't get all the paperwork absolutely perfect the first time. It causes problems in the long term. John and Ann, my parents, got the easements, got the notifications that the committee asked for. We're doing this to comply with a good ordinance to avoid problems in the future. When I have to go to fix this tile in 2071, if it has a 50-year, service life, I don't want to have to debate with whoever the committee is then what actually happened at these meetings. We'd like to get a record of it and get it all clear now and as part of the record. This process, though necessary, is already painful enough. You're not here because we're having a good time at these meetings. I just want to know, why can't we get this done? Why can't we get the paperwork signed? And I leave it up to the committee to answer that question.
I got a question for
Sure.
you. What paperwork hasn't been signed?
The findings of fact and conclusions of law.
Second.
That's what we're asking to get officially recognized. My parents wrote up a version of that, and it hasn't been signed or modified or rejected. It's just, it hasn't been acted on.
So the last meeting was recorded and documented through recordings. Modification was granted, but we didn't do findings and facts, is what you're.
Yes, that's what our lawyer suggested we do to get everything in a
But
proper
the findings
form.
and facts were done in August,
Not for the changes that we made.
but not for the changes.
I'll let John take over.
Thank you.
Okay. There's a couple things. One, the stuff that's happened on permit 20015. This was an administrative permit that was modified. Mr. Vetter chose to bring it to the board, which he is certainly encouraged to do if he doesn't understand something or wants clarification. And the board said, yeah, it's a reasonable modification. Everything that should be done has been done. If there were discrepancies, they have been taken care of. So the problem is that the original four-cornered document is no longer correct and has not been modified. The standard that we have been held to for the last 4 years and other things that we have been doing for everything we've done is to have third-party verification and have everything signed. If you don't have that done, then you end up having to hire lawyers again. We're getting tired of hiring lawyers. We want this done right. Now, we had a zoning dispute. We had a 500-page file. There was a planning and zoning hearing, and after the hearing, one of the planning and zoning board members went up to look at that file. And when he looked at it, it was down to 4 pages. Things happen in those files. We don't know. Now, the page count is back up. It's not the same data that was there before. We want to make sure that we've got a copy of this that's going to be with the Register of Deeds office and with our lawyer's office. We spent way too much time and energy on lawyers the last few years. Now, we earlier submitted Section 9 and Section 10 findings of fact. They were deemed not adequate. And so what our lawyer recommended was that we treat this, as this board is, as you sit now, as a quasi-judicial group. This was a contested hearing, as you remember. We had to recognize those issues raised by the person who objected, the intervener, as they say in the water board world. We have done that. And we have gone through and shown what the facts are and what the conclusions are. This is in addition to what you do on 309 and 310. But we want to make sure that if there's any dispute about this in the future, we have a solid document that we can defend. We have a solid document that the county can defend. When we have done it this way in the past, and we have been in extensive litigation, the judges have said, yeah, here's what the document says, here's what happened. You stay with the document. If you don't have this kind of documentation, then when you have a problem, the judge is going, gee, what are we supposed to do? We got to send it back and go through the whole hearing process, which takes a lot of time and money. So I'm asking that you do 309 and you do 310 and you append this to the end of it, please. And have it signed by both Mr. Vetter.
You're talking this document here.
Yes. Have this signed by Mr. Vetter and by the state's attorney. I've spoken to the state's attorney at some length about this. He is not opposed, but he's not going to rise in support or opposition at this point. He wants, this has got to be your decision. He does not want to intervene in it. Okay.
But you do want us to go through 309.
Do 309, do
Through
310 like
310.
you do for everything else, and include this at the end, please. And then if we have a problem, we've got something we can fall back on and say, here's what happened.
In the past, when a permit was modified, and I'm not sure, but there's not another permit issued?
No,
That shows
there
the
has not been in the
modification?
past.
There's a
Was
note
it-
in the file that shows modification of permit, same number, and it was dated out.
That's the only way it's attached.
And the problem that I have,
The whole packet's in there.
the problem that I have is considering our past history in this county in recent times, when your file is destroyed and shredded and gone, you've got nothing. That's the problem.
All you have is the permit in your hand.
All you've got is a permit in your hand and you don't have anything else to support it. And it's not going to happen again. This has gotten to a ridiculous state. And if I sound angry, I apologize. It's not ridiculous.
Any other questions for John?
No,
Or is talking? Okay,
Okay, thank you.
thank you, John. Anybody else want to speak in favor of this, I guess, project, we can call it? Anybody want to speak against this project? Seeing none, I'm going to close
the public.
public comment and let's discuss it as a board. I guess my thoughts are we do the 309 and we do the 310 finding of facts. I guess I have not had time to read this part. I guess maybe I need to ask Kevin. You were here when he explained it the last time where he put the outlet and everything. The first meeting that was, we were going through all of it and then we got stopped because of a notification issue. Is that correct?
Yes.
Okay.
And I was not here at the last meeting.
That's why I want to be clarify that you knew what we voted on at the last meeting. That he just changed his outlet. And you saw that in the first meeting, in the January meeting.
Yes.
For clarification, may I?
Yes, you can.
I realize that you just got this evening. I had assumed it would have been in the packet because Mr. Vetter's had it for a couple
Well,
weeks.
Hey,
It is in the packet?
This isn't.
His notes, yes.
It wasn't in mine.
what,
The county drainage permit, DP 115 dated
All right, just a second. Just stay there, John.
Okay.
Oswald's. I go from Oswald's,
I mean,
right?
we're asked to look at a document that I've never seen before, so.
We went from Oswald's to the drainage things, what I got. I have everything laid out here.
Yeah, that's where mine goes from.
Okay. I am gonna ask John. You might hate me, or if your daughter wants to do it. Do you want to read the document for the record?
Yes.
Is that okay with everybody?
Well,
Or what do you
yeah,
think?
before we do that, I have a question.
Yeah, go ahead.
So this document, it wasn't in our packets. And it wasn't on the agenda, on mine. When I looked at my emails, I never got a second agenda.
I just looked at mine
So
too.
that's the first I knew about it. So for us to okay a document that I've never seen before.
And
Now,
now,
he's asking for signatures, which we don't have to sign, but is Gary and Rob comfortable with signing it? If it's approved.
but and then my next question is, just a second, John. My next,
I ain't gonna hate you, don't worry.
no. Yeah, I would talk to Gary.
I mean, I'm assuming that it's
Yeah,
all okay, but I don't know what's in there as far as.
I
So,
understand what
yeah.
you're saying.
But I don't have to sign it, but are you comfortable signing?
I was
See, that's-
told that by the state's attorney, we weren't required to sign it. If he wants to sign it, I'll certainly sign it. If the state's attorney signs it. I have no
Now-
issue with it.
now, following also public rule, this has to be on the agenda if we are changing the application. We're not changing the application, but we are, he is asking us to do.
No, all he's asking you, and this was all that he requested, is that he get on the agenda to finalize the permit. And he's just wanting to finalize the findings of fact.
To get documentation of the.
Get
findings of fact.
documentation of what we did before.
Yep. That's the way I see it.
What do you think, Jimmy?
So we're assuming that nothing in here is different than from the permit. I mean, that would be my only concern.
Correct. I mean, all this does is lay out where it is, what happened, the issues that were raised at the hearing, and what the final conclusions were. When you, and Deb, would you come up, please?
I don't know if I can help much.
Well,
The only thing that might make it easier. Hi, I'm Deb Lilly.
Okay, you speak your name.
Deb Lilly, Deputy State's Attorney.
Okay, thanks. Maybe I should have been asking questions.
It's
for you.
okay. My only thought would be if you did your own findings based on those two, and then Mr. Gunderson, if it would be acceptable to you that they just attach as an addendum to what they found, the information that you provided that they are saying they haven't seen yet, would that be acceptable? Because I think what they're saying is they could make their own findings of fact tonight.
correct.
Their issue is with the document that you provided that they're saying they haven't seen. And so if they did their own findings, would it be acceptable then to just attach your document as like an addendum to what they find tonight?
As long as it's signed by the appropriate county officials, I'm fine. I do not want to get in the situation that we did with our zoning permit, where everything's fine, but it wasn't signed, and we end up in another year in court.
and how comfortable, I can't speak for Mr. Clemish. I know there's been some discussion about the findings of fact. And I have not reviewed that either, because I think you were headed then, if that's not where we're headed, then you are not comfortable addressing it tonight. And were you headed that he would have to then come back again? Or was I reading what you were saying wrong?
I was asking the question
Yeah,
in a roundabout way.
right.
And
So,
because the reason I'm going to be honest, because we have done the findings of facts and they've been attached to the thing.
right.
In, you know.
But
this
they
is-
haven't, the findings of fact
This one.
from the updated permit have not been, correct?
Correct. That's why if we did the findings and facts, then the permit, in my eyes, is complete.
Is done, yes. And the only question is, that's why I asked Mr. Gunderson, he wants what he prepared as part of the official record. But my question would be, can Mr. Vetter just attach it as an addendum? And it's not actually what,
Because we're not signing off on that. It'd be
Correct.
Better
and Mr. Clemish.
Mr. Clemish.
Correct.
Yeah, one,
Can you speak in the microphone so we make sure we get
no,
it?
don't go away, because you're not off the horns of the dilemma yet.
You can take this mic if you want.
In the rules of civil procedure, when there has been a civil dispute, the prevailing party usually prepares the findings of fact, correct?
It does just depend.
It
really
but-
does depend. And my understanding, at least of the way the ordinance is currently set up in their procedure, they would prepare the findings of fact.
Right.
And so my thing is, I understand completely what they're saying, which is we can do that tonight. We're not going to address what you are proposing are the findings of fact. You know, is it okay then if you would attach this as an exhibit, however you want to do it? But what they're saying is they are not comfortable
I understand.
going with this tonight, that they would do their own.
I am not upset with that.
Okay.
But partially is because we haven't read it.
Right.
Agreed. And I can go back to that,
But so I think the question is to you, option A would be they would do their own findings of fact tonight,
309, 310.
309, 310, and we could attach this as an exhibit, however you want to do it. Or they're saying you would have to come back and then they would address it and they would go through yours and accept or reject what you've proposed and adopt it as theirs.
my only objection to what you proposed is that it does not include the objections to when we had the hearing. There were, let's just say it, Mr. Healy doesn't think I should be able to do this. We needed to recognize his objections and how they were dealt with.
Right, but typically, if you would do findings of fact and conclusions of law, then the other side could object to what you proposed. And what these gentlemen are saying as a board is they haven't had time to review that to be able to do that.
And
so they could do their own tonight, or they would review this and then proceed at a different time. I don't want to speak for you guys, but
Go ahead and ask a question, Cal.
So if we do our own findings of facts and we attach this as a,
Speaking to the microphone. Sorry.
if we do our own findings of facts and we attach this as an amendment or
Exhibit.
or an exhibit or whatever,
and he wishes it to be signed by those individuals that are listed on the back,
then
can
that's,
he then do that with them?
he could, and I don't know.
Whether or not we say,
Yeah.
we don't have to tell them they have to, but
No, you would only be making your findings of fact, and anything in reference to what Mr. Gunderson prepared would not be in front of you tonight. This would be
but he
then,
could still then proceed to have this.
he could, you could agree that he could attach that this would be attached so that it would make the record complete, but you would make your own findings of fact tonight, not his.
And the board would not be signing off on this. This would be the drainage and the Rob Clemish.
This would be Mr. Vetter and
Yeah.
Mr. Clemish.
Yeah.
Okay, I need to take a vote of my board very briefly.
That's the only thing that I.
Yep, no, you're answering my question.
What our lawyer prepared, he considered findings of fact.
It would end up being an addendum to what they prepare as findings of fact.
So would it be considered findings of fact?
Our findings of facts would be our findings of facts. It'd be 309, 310, and that's what this board would sign off on.
As long as we can attach it to the.
Because
And we're attaching this to the modification.
as a document, it's an unsigned document at this time. And Gary wants to speak.
And remember that we also have video talking about all the objections and things. That's all on video records. So
That's why we're trying to.
And you can always make reference to that too. I mean, you can do your findings of fact and make reference to the video from those, it sounds like you had 2 meetings.
There was a January meeting that was on, and a
Yep.
February, and I know Kevin was January. Were you here on both meetings?
Yeah.
I was on Zoom on the first meeting and the second meeting. I was
Yeah.
present.
Yeah.
So. Okay.
Do you want me to read it into the record very quickly?
I don't think we have to if we just attach it as an exhibit.
But do we want to read it so it's on audio record, audio and video record that we've heard it?
I have no objection to that.
But the thing is, we're not gonna be signing it as we were just talking. So I go for it. It is a added stuff that.
Okay. Concerning Yankton County drainage permit number DP 20-015 dated August 6th, 2020. Location, section 10, 9555 Yankton County. Topography, fairly level. General direction of the drainage is from east to southwest. Gunderson's, later JHGS Farms LLC, JHGS owns the west 1/2. Linksteads own the southeast 1/4, which is partially drained through JHGS. David Healy owns the northeast 1/4, which drains into both Linkstead and Gunderson's properties. Healy tiled in 2014 using a line under JHGS northwest 1/4. October 2013, the owners of the south half of section 10, Linksteads and JHGS commenced a joint tiling project, Yankton County drainage permit number 45. Easements were signed between the parties and allow crossing Walshtown Township right of way. In August of 2020, JHG applied for and received an administrative permit, DP 20-015 for farm tile drainage, starting in section 10, 9555, with an outlet in section 16, 9555. DP 20-015 was an administrative action and did not require notification or publication. Prior to construction and with notification to Yankton County, JHGAS moved the outlet less than 10% of its total distance from section 16, 9555 to section 10, 9555, which is allowed by the Yankton County Drainage Ordinance, section 3.03.1A. Both properties in section 16 and 10 are owned by JHGAS. The modification to DP 20-015 used a natural waterway that begins in section 10, 9555, continues into section 15, 9555. The county was notified of modifications before work commenced. The modification did not increase the size of the outlet, nor the area drained, nor the volume of water in the watershed. No objections were raised. After construction, a question was raised by a drainage commissioner. JHGAS blocked the drainage pending review. On December 29th, 2020, the Yankton County Drainage Commission planned to meet to discuss a request to modify DP 20-015. JHG requested the ratification of the modification. Notice of the meeting and date of the time of the December meeting and the purpose of the meeting were sent to affected landowners with land 1/2 a mile upstream and 1 mile downstream of the actual outlet of the project. The county drainage administrator was notified of the mailing and the names of those to whom it had been sent. My, that's a terrible sentence. A notarized affidavit of mailing was not completed. No one filed a written complaint within the 10-day objection period. The drainage administrator opined that the affidavit of mailing was not required for an administrative permit. The December 29th meeting was canceled due to weather. On January 26, 2021, the Yankton County Drainage Commission did meet to consider a formal request from JHGAS for the drainage administrator to ratify a modification of DP 20-015. David Healy, Drainage Commissioner, was recused from voting, but was allowed to participate in discussion. Healy did not file a written complaint within 10 days after the mailing date on the affidavit of mailing as specified in YCD 03005 or at any time afterwards. The Healy owns property more than 1/2 mile upstream from the outlet of DP 20-015. Healy land drains onto Gunderson land. Healy property is not affected by DP 20-015 or drainage pursuant to it. At the January 26th meeting, JHGS was directed to send notices and file an affidavit of mailing pursuant to the Yankton County Drainage Ordinance, Section 304, and to request an updated easement from Walshtown Township. On the 29th of January, 2021, JHGS delivered to the Planning and Zoning Office, number one, a copy of the signed and notarized affidavit of mailing listing the names and the addresses of the landowners on January 28th, proving notice that was mailed. Two, a copy of the letter sent to the affected landowners. No written objections were received after this notice was given. JHGAS obtained the easement from Walshtown Township to use the right-of-way under 299th Street, and which was delivered to the drainage administrator by email on January 29th. Required notice of the meeting had been given, and the YCDC met on February 23rd. Commissioners present, Craig Hansen, Dan Grant, David Healy, Casey Cruz, Sherry Loest, and Frank Kralachek. For the item involving JHGAS, Commissioners Loest and Healy were recused. A question was raised about notices. The drainage administrator said that notice had been given, although it is not required for a permit modification. The drainage administrator acknowledged there had been no written comments from either the December or the January meetings. After public comment was closed and after discussion, the Yankton County Drainage Commission moved and seconded a motion to direct the Drainage Commissioner to modify permit DP 20-015 with the outlet located on the southwest 1/4 of Section 10-9555 and approved the modification based on these determinations. The area drained and affected properties and outlet size are not changed. The new outlet is appropriate under Yankton County Drainage Ordinance Section 3.05.02 as drainage into a naturally defined waterway. DP 20-015 was properly issued under the Yankton County Drainage Ordinance based on Section 305. Notice was not required for permit 20-015, and it was an administrative permit. However, the Yankton County was notified prior to modification and construction. Construction was started on a timely basis. Healy was not required to receive notice. Healy's lands abuts and is dominant. JHGAS property is subservient. Healy property is more than 1/2 mile upstream from the outlet and is not affected. Prior to the 23 January 2021 meeting, JHGAS provided, as requested, an affidavit of mailing and a new Walshtown Township easement for use of the township right away. At the 23rd of February meeting, the Yankton County Drainage Commission recognized that all the prerequisites or conditions have been met. The as-built outlet location is a drainage improvement. It reduces erosion risks in a natural, well-defined waterway with erosion protection. The Yankton County Drainage Commission directed the Drainage Administrator to issue a modification to DP 20-015 that shows the as-installed outlet. The rest of DP 20-015 is unaffected. JHGAS may operate the valve and drainage project without restriction. The motion was made and seconded to approve the modification of DP 20-015. For the reasons noted above, the motion was carried. The last page has a pin on the GPS outlet with the GPS coordinates. 43 north, 97 degrees west.
Okay. And the motion was carried by roll call vote, right?
Correct. And I hope I was legible through all of that.
Yeah, very good. Very good. You must read at church.
No, cantor at the synagogue.
Okay. I think that's all the questions. We'll go back to closed session.
So we're doing findings of facts on the modification. If you can give us a 1 minute.
Okay.
What the modification was.
The modification was moving the outlet from section 16 to section 10. And if you think of a checkerboard, Linksteads own black and we own red. So starts on Linkstead, goes to us, goes to Linkstead, goes to us. In that southwest corner, if we go underneath the corner of the road, we can go around Linkstead. And the, not going to go into that. But anyway, at the last minute, and I mean the very last minute, things got changed and we ended up going back in. There's a large creek on our property, comes out of our property, that goes into a sock dam on his side. And so we moved the outlet. We shortened it up a couple 100 feet and put the outlet into that creek. At the same time, Linkstead's installed a tile. They're 5 feet apart at the outlet. Those outlets are in the southwest corner of the quarter. This is the southwest quarter in the section. Healy's own the northwest quarter, northeast quarter. So they are more than a half mile away from the outlet. And it was a very simple process. We did install, when there was a question raised over what we had done and whether we had followed the rules or not, we installed a valve on it and we closed the valve. Kind of a moot point last fall, but we still did it. And before we did this, we thought we had permission, and my mistake at that point was not getting it in writing, which is why I'm so insistent now, because every time I don't get something in writing from the county, I end up having to hire lawyers. And that's why I'm insisting that stuff get signed and everything's out in the open. We're not trying to hide anything. We're not trying to pull anything over here. So.
Any other questions from the board?
No.
Answer your question.
Yeah, I just wanted to refresh myself what the modification was, because that's what we're doing the findings on. Because the original permit was.
Original permit was it drained from us to us. And so administrative permit. And we're still going into the same blue line.
Still going to the same blue line.
Still going.
You shortened it up and went a different.
Yeah, we just shortened it up, and now Larry gets water in his stock dam.
Okay.
And avoid running a lot of water down a ditch,
Yeah,
a roadway
Right.
ditch.
Yeah.
that's the other thing. Instead of running water down a ditch for a couple hundred feet, we're running it now into, you could hide or herd elephants in this creek. I mean, it's 25 feet deep instead of down a shallow road ditch. Okay.
Thank you.
Thank you again.
Yes, we're closing public comment again. Okay, as a board, any discussion?
Go through 9 and 10 and
Go through 9 and 10.
Before we go through 9 and 10, are we gonna attach these two documents to the permit?
I would be in favor of, I don't know if that's a separate motion, but I would. be in
Or do we
favor
do
of-
that as a motion when we?
I think we do that as.
Okay, let's go through the finding of facts. 3.09. Kevin, you want to take the first one?
Okay. Number 1, under 309. The flow or the quantity of water to be drained will not overburden the water course into which the water will be drained.
Let's answer that clearly. I'd say no, he changed his outlet to go into a stock dam.
So it will not overburden the water course. So that would be yes.
Good, yep.
Number 2, the drainage will not flood or adversely affect the land of the lower proprietors, or in the case of an impediment to drainage, whether such an impediment will not flood nor adversely affect upstream landowners.
Okay, we talked about that. He actually's got a valve on it. I actually would recommend maybe leaving the valve in there. Just for, you know, if we do have flooding like we did in 1819, that he has a option if Link said, hey, my dam's gonna get in too much water, shut her down. So we should add that valve stays in.
Friendly amendment.
Yeah, okay. Let me write this down. Amendment. Valve stays on. Any others? To add to number 2?
no,
Anthony? Yeah. Okay,
No.
go ahead.
Number 3, easements will be granted where required.
got them.
I believe we have all them.
Yep.
The drainage will not negatively affect agricultural productivity.
I think we answered that. It's going to improve it.
Should improve it. The land affected or the land drained is and will remain rural in character.
I
It's
think so.
ag land and it should remain rural. When the land to be drained is rural land and presumption and factors set forth in SDCL 46A 10A 20 will be satisfied.
46A 10A 20. The land received, the drainage remains under rural in character. That's
Yep.
true. The land being drained is used in a responsible manner.
Yes.
I'd say yes. The drainage created on unreasonable hardship or injury to the owners of the land receiving the drainage, and it has easements, and discussed that he wanted to put it in his stock dam.
Yep.
Okay. Sorry. The drainage is naturally occurring. Yep, sorry. The drainage is natural and occurs by means of a natural water course or established water course. So he's putting it right where the water course is going.
Yep.
The owner of the land is being drained does not substantially alter on a premises base of the course of flow and the amount of flow or the time of flow from that which would occur So he's not altering anything to drain. The water he's draining is going that direction. And no other feasible alternative drainage system is available that will produce less harm without substantially greater cost to the owner of the land being drained. And I think he shortened it up. He's draining in his own field.
Yes, it should meet that.
Should meet that. Okay.
Number 7, adequate precautions have been taken to ensure that the roadways will not be negatively impacted.
He has the easement from
the
Walsh Township. Township.
And got a valve in there too.
And has a valve. Okay.
Recommendations from the Drainage Commission and the findings of fact.
We made a recommendation already that the valve stays on.
Okay. And such other factors that the Drainage Board determines to be pertinent to the application. I think all the things we talked about above is
It's all covered.
Now, when you say the valve stays off,
On. Or the valve stays there. He can.
it stays attached.
Stays attached. Thank you. Thank you.
Thank you.
Thank you for clarifying it.
Because I was like, oh, good God, we just shut it off.
No, the stays attached for occurrences where controlling the dam water or anything else. It's there already. Let's be neighborly and take care of neighbors. Okay, Nancy, you want to do 3.10?
Do I?
Yeah, you want to read it? We'll go through them quick.
You really want me to stumble through that?
Yep.
Okay. Number 1, drainage into the receiving water courses which do not have sufficient capacity to handle the additional flow and quality of water shall be considered to have an adverse effect. The applicant shall be responsible to provide sufficient evidence with third-party verification when requested by the Drainage Commission or the Drainage Board.
Okay, let's answer that question.
Well-
We did not ask for a third-party verification. We decided there was a significant flow. And it was still going through the same course. Am I missing anything?
No, I don't.
think you're good.
All right, I just want to make sure. Okay.
Number 2, whether drainage is accomplished by reasonable improving and aiding the normal and natural system of drainage according to its reasonable carrying capacity, or in the absence of practical natural drain, a reasonable artificial drain system is adopted.
So I'm going to say the tiling is adaptable drain.
Ready? Number 3, the amount of water proposed to be drained.
We said it was adequate
Yep.
for the outlets and the design.
The design and other physical aspects of the drain. All looks pretty good to me.
That's
The
been
impact.
presented,
of-
That's been presented twice.
Okay. The impact of sustained flows. Well, there you got that valve if you need it. Recommendations from the Drainage Commission and the findings of fact.
I think we covered them all.
Only recommendation I got is attach it and sign it.
Okay, do you want to make a motion to our findings and facts
Sure.
to approve our findings and facts? And if you wanted to attach that,
Okay, I'll make that motion to,
you approve 3.09 and 3.110.
correct.
You want to go ahead and state it how you want to state it.
Okay. I hereby make a motion that we approve the findings in fact under 309 and 310 and attach them to the documented 2015?
That's a permit number. I would actually call it attaching the document of the GPS coordinates
Okay,
and the document that Gunnar sent that is unsigned in front of us, but it's a document explaining the procedure that we went through. And Gary Vedder and Rob Clevish, if they want to sign it, they can sign it. But we are attaching those two and then our findings and facts.
Correct.
Do I have a second?
However you want to write it up there, Mr. Chairman.
I'll second that.
Okay, any discussion on this motion? I like the idea that we have the GPS recordings, so. And, I actually want to make amendment to our motion that we leave the valve attached to the project.
Okay.
Do I have a second on that?
I'll second that.
Okay, we have a second to that part.
And I'll lie it.
Okay,
You're very attached to my valve.
I am. A $100 valve. Easy.
Yeah, I'll take it.
What's it?
We haven't done voted on.
No, we have not voted on anything yet. Anything else? We're in discussion right now.
Yeah.
Anything else we need to cover with this?
We've got it all attached. The amendments. Then it would be a roll call vote, wouldn't it?
I think so. I want to ask the deputy attorney, are we missing anything here?
Instead of could sign, I think it should sign. Every time we do not get a document signed by the county, we end up in a mess.
I think their point is, I don't think they can tell Mr. Vedder or Mr. Crumish to sign your document. They're attaching it, but I don't think they are comfortable telling Mr. Vedder and Mr. Crumish they have to sign your document.
They don't have that ability.
I think that's where we're at. I think they're gonna attach it, but whether or not.
Yeah, you know where I'm going.
I do, but their point is they can't tell Mr. Vedder and Mr. Clemish that they have to sign that. Can they recommend it?
Can they recommend?
If they find it accurate. But then that would require them to review it, and that's why I said your other option was just to wait so that they could review it and prepare.
Would you want to wait and review?
Honestly,
I don't want to end up in court again.
I know, but
For them to say, I don't think even if they did exactly what you said, I don't know that they can legally obligate Mr. Vedder and Mr. Clemish to sign this document. They're the ones that have to do the findings of fact. Under the ordinance, it has to be the drainage commission.
go ahead, John, we're in discussion.
I would be comfortable with, adding the statement, if Gary Vedder and Rob Clemish are comfortable signing, they may sign it.
Yeah, but I can't force you to go sign something.
No. But I don't know if that needs.
But all of your information, Mr. Gunderson, is one, in the record, and two, will be attached to their findings of fact. So whether or not Mr. Vedder and Mr. Clemish in the end would sign this, it doesn't impact what the Drainage Commission just did tonight. They did the findings of fact.
On the modification.
On the modification, correct.
I'll go with what she said.
Okay, any other questions?
No.
Roll call vote?
Kralchek,
Aye.
Kirschenman,
Aye.
Hanson.
Aye.
Motion carries. Look. I guess we can ask for Sherry Lois and Dave Healy to come back and discuss possible ordinance change. Oh, wait, we have one more. We have Dave comments for Dave Healy. Dave, do you want to do comments? Yep, we're ready about. Yep, it is 8:25, 26. And we're doing to amend it. Agenda. Healy wants to make some comments on the Gunderson application.
Mr. Chairman, I'm going to object. He is recused from commenting on this permit. And that, using his position to try and beat the board up when he is a board member, is a clear violation of the rules on recusal.
Who said I'm going to beat the board up?
Mr. Healy, you're not supposed to comment on one way or the other. You're recused from meeting.
At the first meeting, we determined that I would be involved in the discussion, but would not vote on the application.
And at the second meeting, you were fully recused, and you were recused on this one. You sit on this board.
The agenda's been approved.
Okay, so what we should probably do is to have you speak during public comment. And you have 3 minutes during public comment to do that. So
Sure.
When our chair calls for public comment, you are welcome to come up and speak.
Okay.
Because anyone can speak during public comment.
All right. I guess we are done with the amended agenda. I guess we're going to go to 7:20 public comment. Does anybody have any public comment?
I do.
Okay.
Do I have to say anything? I do.
Yep.
Go ahead and state your name, your address.
David Healy, Mission Hill, South Dakota. I'd first like to make it be known that I'm not against Mr. Gunnarson's application. He's trying to give you the perception that I am, but I am not. The fact that he even states in his comments that he read to the committee state that I did not file a written complaint against his project. And so I'm as impartial, I think, as any other board member. But being what it is, I've been tasked by the neighborhood to be the messenger, as we are still seeing a number of, how would I say it, complaints from the neighborhood, in that they see that the procedure that Mr. Gunderson followed was not what you'd call following the ordinance. A number of people in the neighborhood have also had their projects and gone through the application procedure and had to follow all the requirements, dot the I's, cross the T's, send notices out, attend meetings, and they felt that was fair. For some reason now they think that Mr. Gunderson has bypassed some of this. The other thing that has been brought to my attention was that the last meeting, it was determined that the drainage ditch that Mr. Gunderson was draining into was vested, and that is not correct. That ditch is not vested, and the decision by the committee was that the application would be approved because of the fact that it was a vested drainage ditch, and that is not correct. It is not a vested drainage ditch. So they're thinking the application was approved based on false information, and don't feel that is appropriate, and requesting that the committee review the application and possibly impose fines for some of the misinformation that was brought forward to the committee. like I say, I'm just a messenger. Shoot me if you want, I guess. Just trying to bring information to the committee, all the information.
Okay, I got one question. It was stated that it was a vested ditch, and you state that it was not a vested ditch.
That's correct.
Just thinking. How do we prove who? It doesn't matter who was right or wrong. I guess the vested ditch should have been found by the drainage administrator because he gave the application to the first permit that did not come to us. And he said it was explained to us that it was a vested ditch coming through the county office. And because Gary Vetter, in the application, he approved the first application clear back in August, if I'm not mistaken.
There was some misinformation on that.
But if he was doing his documentation, all that documentation should have been in front of him, or he should have asked those questions. I guess as a committee member, I don't have time to go over to the deeds office and find that. I guess, I don't know how the rest of you feel about that. I guess I'm gonna stop there.
So you're saying he should have determined if the ditch was vested before the meeting or after the meeting?
It should have been determined before he got his August permit. The August permit never came to us because it was a vested. It was a in-house permit.
You know, the August permit didn't come to you because Mr. Gunnarsson stated that he was going to a blue line, and that was determined to be inaccurate. He was not going to a blue line.
I'm asking
on his property,
and he's answering it. Okay. Any other?
So then it became a vested ditch.
Any other questions for the board?
No, and normally during public comment, we don't have a back and forth. You have public comment and then the next person makes public comment. So I think at this time, it's best we close the discussion.
Okay, sure. Thank you for your time.
Any more public comment? Yeah, just a second.
My name is Grace Ann Schiefen. Irene, South Dakota. I'm half of JHGAS Farms. Those were vested drainage rights. I typed them up in 1985. I typed 9 pages, double-sided, and we registered them at the courthouse. They were vested. Everything that is required by the ordinance, we did. We sent out notices. We got easements. The easements were in place from 2013-14. We got permission from the county a second time. Everything was done properly, and we did not cut any shortcuts. Thank you.
Thank you. Any other public comment?
I thought we had a copy of it here. The other thing is the original permit. I got to throw the bullshit here. As Mr. Healy is fully aware, the original permit outletted into a blue line on our property. The reason that we had the hearings is that when we did the modifications to the hearing, as Mr. Healy is fully aware, is that we're about 150 yards short of the blue line. We have an easement with that neighbor. Mr. Healy is aware of these facts. He watched us put the tile in. He did not object at the time. None of the neighbors, no one has come to us and complained. Now, I don't know where this community thing comes from, but these collateral attacks are bullshit. And this is why Mr. Healy has been recused from dealing with this permit. And coming in from the side on public comment like that is a violation of the rules. Now, he might think it's fun. He might think it's really cheerful and it shows that he's a big man, but it's bullshit. It's a classic case of Arcellus equus.
Can I comment?
No.
Any other public comment?
How come Mr. Gunnarsson was allowed to comment again?
It was his first public comment for 3 minutes.
Okay.
Any other public comment? Seeing none, I'll close that portion. All right, is there any discussion on the board about that? I don't think there's nothing we can
Nope.
say or do. Okay, seeing none, moving on to discussion on possible changes of the ordinance. I know we talked about the last couple meetings, different changes.
Yep, so what was in your packet were the things we discussed at the last meeting. And I have received some feedback for maybe a few other minor changes as well. So first, let's discuss any of the red that was in your printout there.
Page 15.
Page 15 was simply updating that intermittent stream definition. So they are different definitions versus the same definition. So that would be the first one. Next would be on, oh, they all say page 15. Oh, well, that's funny. Oh, we need to get that one clarified, don't we? Well, that's funny. So let's go to section. So let's go to
number 19.
Yeah, we've got.
Ordinance, county drainage ordinance number.
Yep, so section 3.03, let's go by sections. Yep. And if you look at the next page at the top, item A, we were concerned with that 10% actual location change. So we put 100 feet in there. So the line reads, the actual outlet shall be placed within 100 feet of the proposed outlet location. Distance is greater than 100 feet, must obtain administrative approval. So essentially you can be 100 foot upstream or 100 foot downstream of where you said. So you've got like a 200 foot variance in there. So if you run into a rocks or something, you can move it. Does that seem reasonable? That's what we discussed last time.
I wasn't here for that, but I think 100 feet is too restrictive.
You think so?
Unless it's easily handled with a phone call. And the reason I say that is you have a tiling project ready to start, tile plows there, and they realize that that outlet, it's better 300 feet away or 200 feet away.
Okay.
All of a sudden you're limited to 100 feet. So can they call the administrator and say, hey, we're moving it? Or is it going to be another meeting, which then
no.
you have to move out? I mean, it's.
So distances greater than 100 feet must obtain administrative approval. So that would be calling Mr. Vetter and just so it's recorded.
Say, hey.
Yeah, yeah.
As long as it doesn't lead to a big delay and they're within the same parameters of the field.
And the outlet stayed the same size and stuff. So
I've seen it where all the proper easements are in place.
Yep.
If
So
he needs a new one, he has to get a new one, you know.
26,
At the end of the day,
30,
the
40.
easements are gonna have to be in place.
Right, but as long as yeah, because 100 feet isn't very far.
Yeah, I actually thought about that too. I was
Do you
thinking,
want to go to like 200 feet?
I was thinking like
Give a little bit more
250,
room.
Maybe give you a little bit more room because actually 100 feet's not even a sprayer boom. My sprayer booms are 125 feet. That's 48 rows only.
Okay.
So I was thinking
A lot of times in an outlet.
we're talking
Just speaking-
talking about 5,000 feet. I'm you know, that gives you a total of 500. You know, because you think about it, 48 rows. I know we're in this small building, but you get in a big field. That I actually thought about that.
Just saying though, if it would be greater than 250, then they would have to call.
Yeah, greater than call you, but You understand what I'm saying?
Yeah, no, I get it.
You had a 24 row planter twice, one round, that's all it is.
I get it.
My only concern would be the downstream person. He's expecting water to come here. Now it's 300 feet
Well,
over
if
here.
it changes
You know what I
from the
mean?
landowners, it still doesn't affect the mile downstream because that's from the property line. So the notification.
See,
nothing would
maybe,
have
that's a
changed.
maybe, you know, might not, it shouldn't. It should not be administrative approval if it dramatically changes anything.
Yeah, if it crossed another person's property
Yeah,
or went to a
something,
different
yeah.
area, then that's
Yeah.
another.
That's
That's
different.
another different issue.
Any way of notifying the downstream person, something like that, just, you know, so he doesn't think that.
But that's not even the end rows, 250 feet. That's not even end rows of the field. So I make a motion that we move it to 250 feet.
Oh, we don't need a motion for that,
Okay.
just suggest.
Yeah.
250. Craig, are you comfortable with 250?
Yeah.
I see what you're saying, David. It just
Because
matters.
that's
Yeah, my
up-
only
if it's
concern is
250, it's up
parameters
and
now.
down, right?
He's seen the permit, he said, okay,
Yeah.
it's coming here.
Yeah.
Yep.
Now, all of a
So
sudden
So
it's over
500
here.
total.
What's going on here, guys? You know,
You know, I always,
create controversy that we can hopefully avoid.
okay, I always have to go to my years of running track, and 100 meter dash is 110 yards, so that's 330 feet. Sorry, guys, that's how I do things. So I'm picturing standing on the track, looking left and right. So 250 seems reasonable to me.
I'm gonna have to get her out the planner. Just sprayed her.
All right, so the next line down was the new B, and now it reads, all required easements and any required maintenance agreements shall be provided as part of the application. So we just added the easements in there, and if there were any required maintenance agreements. So that wasn't too much of a change. So when we get down to 304, we essentially changed the burden of sending notifications from the applicant to the zoning office, and that was really their request. One, it ensures it's done, and it's done consistently, and
It's signed.
it's signed. They're going to use certified mail receipt. So that was essentially the change there. So a certified mailing receipt shall become part of the permanent record. The planning department shall give notice of the application for the drainage permit to the following parties.
Is that the same way it's done in zoning?
That's how we are moving to change it. That's going to
So
be
it would be the
another
same.
amendment, so it would,
We got the same issue with people claiming they didn't get letters.
yep.
Right. Okay.
So, yeah, so it's just easier legally to have that record. So when we get to number 1, as detailed above, all abutting property owners and all property owners 1/2 mile above and 1 mile below the outlet of the proposed drainage or documented blue line. So the goal here was, it used to just say upstream and downstream, but we're trying to notify people abutting the property in case they want to join in. So this hopefully will curb some of those issues of, oh, crap, you got the tile, you're putting it in. I sure wished I would have known. I would have tied in.
So now we're back to the 1 mile. It says here below the outlet. Is that 1 mile from the outlet or 1 mile from the abutting property?
That would be the outlet.
That outlet.
So you've got the outlet there, and then you've got the abutting property as well.
I was under the assumption, or in the past, that when letters were sent out, they were sent from the property line.
See-
Of the 1 mile, for instance, like in the project that we did tonight for Oswald's, if that was up in the field a ways, the applicant 1 mile south of the road would still get a letter.
What I seen Garrity do is you take the outlet and basically draw a 1/2 mile
Draw.
circle for the upstream and draw a circle, 1 mile circle
Which
for the
most of the time
downstream, and
catches
that's,
everybody in that area anyway.
you know, that's
Yeah,
how he did it.
and I do believe this will catch that as well, because like if you looked at all their abutting property, they're essentially getting all of those people. The people to the south would have been notified because they're abutting, even though there's a road there. To me, they're abutting, they're around it. So I do believe we're still going to catch
That's where moving the outlet
all of
would
those.
affect.
And we're generally generous with adding a property or two.
More notifications
Yeah.
are always better.
Yeah.
Especially if you come in, you just.
Right, because that'd be the worst part is if somebody come back and said, they moved the outlet 250 feet, and then now that actually adds another property and it didn't get notified.
To be honest, I figure out who's gonna get letters. I use a lot of line because it's easier than measuring. I just go to the bottom of the property, even though it may be.
Right, so you're actually going a mile and a quarter maybe, or, yeah.
It's just easier to.
do it.
So we're covering it.
Okay,
But if that's something that we would want to stay in the future all the time, does that have to be changed in the ordinance?
do we want to reword this
Or
then?
is it okay just let the alone?
What she did redline it to change that.
Well, from the abut. As detailed,
How
all
would you
abutting property owners
Describe that.
and all property owners. So that should,
That's why we're getting all the butt-it ones.
So the next section so far that we talked about last time was 305. And this is to clarify what administrative permits are. So number 1, a proposed drainage project which outlets directly from the applicant's property into the legally recognized river and streams, both permanent and intermittent blue lines as defined herein and as delineated on the most recently published maps. So this is essentially, blue line is on the applicant's property, administrative permit. So number 2, a proposed drainage project which outlets directly into the legally recognized rivers and streams, both permanent and intermittent blue lines as defined herein and as delineated on the recently published maps, but crosses a roadway or abutting property in order to reach the blue line. All parties have received a copy of the drainage permit application materials as required in the notification to other parties. A permit may be issued if no notified landowner files a written objection within 10 days after the certified mailing date. So in other words, I want to drain my property. Frank's my neighbor, and he's got the blue line. So if I send out all my notices according to the previous section and nobody wants a hearing or has an objection, the administrator can give me a permit to do that.
so the
After the 10 days.
The permit that we did tonight for Oswald's could have been done administratively.
Yes.
But they were crossing property lines, but they had all
Wait a
the easements
second.
in place.
Yep, and nobody complained around the area.
And
10
they all-
days later, he could just got his application.
That makes sense because just, there wasn't very much distance there between his
No.
property line and the.
No, and I agree that
It was
you could have
on
just
his
done that
side,
one.
So it doesn't seem like we should have been able to do that versus bringing it to the deed.
Well, what triggered it to come here then? The property line?
Because he had property lines.
Currently, yeah.
So the last one moves to a proposed drainage project which outlets directly into a,
Can I ask something?
you bet.
So if somebody does complain, files a complaint, does that force it to come to the meeting?
Then it comes to the meeting.
So is that
Yep.
stated in this? or
Permit
is
may
that
be
just-
issued if no.
It's assumed.
I can add a line that says if an objection is filed, a hearing is required
Or they
in
have
front
the
of the
right to
drainage.
hear it.
I can add that.
It already says that up there in the beginning, below the headline. All other
Tonight.
drainage permit applications shall be Yankton County Drainage Commission / Yankton County Drainage Board public hearings.
Okay, yeah. I'll put a little note here and I'll read this again with fresh eyes tomorrow and see if we need to add that. just for, better to have more clarification than
Yeah, I
less.
think it's, that's pretty clear, I believe.
Okay.
More is better.
Hearing. Okay, so for number 3, a proposed drainage project which outlets directly into a permanent or intermittent stream which is not listed on the USGS topographical maps. So we all know there's streams out there that are not really blue line streams. So this covers them. All parties have received a copy of the drainage permit application materials as required in 304. A permit may be issued if no notified landowner files a written objection within 10 days after the certified mailing date.
How is that different from 2?
Because it's not on a blue line map.
Yeah, isn't that what we're also saying?
Number 2 is a blue line.
I was taking number 1 is a blue line on the applicant's property.
Yep.
Okay, and number 2, directly into the legally recognized river and streams.
It's a blue line on someone else's property.
Right.
And number 3 is not a blue line, but it's recognized as a permanent or intermittent stream.
Who determines that?
Yeah.
If it's a recognized.
We have a blue line layer right on our GIS beacon site.
It shows lines that are not.
Shows the lines of beginning of streams.
Right.
Beginnings of streams, even though they're not considered a blue line. Okay.
One other question that was raised about the administrative approvals is that's really not addressed in here at all yet. But if we have a project where there's an existing project to the north, existing project to the south, and they connect in between the two, is there any reason that can't be an administrative approval? Same outlets?
Or tying in, essentially tying into current
Tying into
project
current
with the same
project.
outlet.
Adding more lines.
Yeah, adding
It would
more
say,
lines.
like, for example, some of my fields, I went from
But you know, we're
120
getting,
feet to 60 feet.
yeah, because we're getting to the point
We're
where
gonna be doing some
there's a
of
lot of projects out there already, and so there's some people that are taking the plunge and connecting to it now, and I
Well, I
just,
think that if their outlet, it's just a matter of their outlet. So if
Right.
they already have an
Right.
easement to get into that outlet.
yeah,
Not
it's just
changing
not
the size of
stated
the
in here, so that's why I wanted to bring it
So
up.
like a number 4 to say modification of current systems, but the outlet doesn't change, and I'm not saying that fancy.
Yeah, something to that.
Would we be okay with?
I think the question would be, would notices be required? I think you
I think
can
we'd
accept the
still-
project.
Still do the 10 days.
You still would do the 10
notice
days,
to the
then, yeah.
neighbors.
10 days to the neighbors. So if in case you're going and doing, you
Right.
got an 80 or
But it
160,
still
and you want to do
saves
another
that
80.
Well,
Yeah.
A fair
Why
amount
not
of
just-
time.
Why not just change number 3 to add in? It says which outlets directly into a permanent or intermittent stream, which is not listed, but you could also add existing tile line.
That works.
Or existing tile line. There you go,
Add
Kevin.
Existing tile line.
I'll
into
figure
that.
out how to do that. Or existing.
So modifications could go through the administrator, which I think they already can. So,
Using, with existing tile line using the same outlet.
Yeah.
That would work.
yeah.
I'll try to fancy it up a little better.
Well, you don't need to fancy it for me.
Yeah, we're trying to keep it simple here.
I got an English teacher sitting at the back, so I gotta make it sound good.
Keep it simple.
Okay, all right, so I'll make that note there. So as far as the Drainage Commission required hearings, the only word we added was the word directly into a permit, which does not outlet directly. So number 1 under the Drainage Commission is essentially the blue line is out there, but I'm gonna outlet in my pasture and it's gonna run to the blue line. So those have to come to the Drainage Commission so we can review erosion concerns. Is it,
But
you
is
know,
You could also add that same wording into that one. Says a proposed drainage project which does not outlet directly into a permanent or intermittent stream or a tile line, existing tile. You're doing the same thing as you're doing the one before.
Yeah, are we redundant here? You're saying that if, let's say someone's gonna outlet into a pasture and just basically let it flow across the pasture to a creek
That would be
or
different.
and that's what number 1 is.
Right. Or it could be taken that if it does not outlet directly into a stream, it has to come here. But if we do directly into another tile line project, it doesn't have to.
I see this as being administrative. There again, as long as the
They make the
downstream
choice.
easements are in place and notifications have gone out.
If one covers it, then it's, if by 3053, they can do it, then under number 1, under Drainage Commission doesn't come into play.
So you guys are good if we've got people coming to Mr. Vetter saying, I want a permit to dump in my pasture and the blue line is a quarter mile away?
No, only if it's into an existing tile.
So you're
tile line.
talking, you're still
That's
on the
same-
tile thing.
Yes, I didn't know if that had to be on this one.
Okay.
Also,
I think if we're gonna allow into an existing tile, we need to just leave that on number 3,
just leave that on number
on
3.
administrative. So this one just essentially is,
Okay.
you're not dumping into tile, you're not dumping into a blue line, you're not dumping into a stream that really isn't a blue line, but we consider it a stream. You're dumping in a pasture or whatever. Your feedlot.
And the pasture would be on their own property.
Not necessarily. Could be your neighbor's property if they're okay with it.
They're okay
Right,
with
then
it.
an easement, of course.
Because
would
we've
be
had one of
required.
those before where it ran on their property and into their dugout.
Mhm.
Multiple ones.
Yeah, so technically those wouldn't have to come to us unless someone lodged,
Again, right, yeah. Easements are in place,
Okay.
and notifications were
All
sent
right.
out, and there was no opposition to it.
okay. So I'll try to clean that up, and I don't remember any other changes we discussed back here. So the ones that, for tonight that I'm bringing, let's go back to number 1.03. So that'll be purpose. And this is a philosophical discussion here. How this is written is, we are governing the drainage of water within Yankton County. And that is extremely broad. So it's been suggested that maybe we try to limit that to agricultural use and even to go so far as to say subsurface. Any thoughts on that?
We have never, we should almost put subsurface because we have not done any surface drainage that's done by the state. and
That's more
federal.
state governed.
And
I
federal.
think subsurface would be acceptable. Yeah.
So to govern
Defines it.
the agricultural subsurface drainage of water within, okay.
So if I want to dig a new channel across the field that's not existent, we don't need
No, it's
a
happened.
drainage permit.
It's happened by the airport. We denied the tile permit and he went and dug the ditch.
Was it an existing ditch? They just cleaned out, or was it a whole new ditch?
It was not a blue line, but it was a course of the water.
I don't recall that one. What was that about?
Because he could not get the blue line permit easement from his neighbor.
Mhm.
So he took it in and backhoed 4 feet, 5 feet places. And cut the water to wall. And he got permission from an NRC and, yeah.
Okay. So everybody's comfortable with that
I-
focus? I'm comfortable with it.
I think, because we haven't
We're
done,
gonna make this only about time.
Essentially making this ordinance about tile,
and not residential.
ag tile,
And not residential.
not residential.
Right, because we had all of them come to us about, in the country about tiling around their house.
Yeah, do you recall the one he wanted?
I put
to
tile
take a
around
ditch
my
or
house.
one that
Well,
run
he
over
said,
it?
well, he came to
That's,
the,
yeah.
he came to the board because they didn't know what to do with it. Really, we didn't see a need for that because it's residential.
Right.
It was, he wanted to
quantity
drain
is-
out to the tile
is
off to
small.
the ditch. Yeah.
Okay. So the next one would be Drainage Commission just below there. And right now we say we have 9 members. The County Commission moved the Planning Commission to 7 members. So essentially you have 6 at large and 1 county commissioner. So it's been suggested that we move this commission to 7 members.
I'm gonna object to that for one reason.
Okay.
There's only 5 of us tonight. We're all busy. You know,
Mhm.
and to get 5 of us, I know that we all have different schedules, we do different things, and it seems like one meeting, some of us are here, and next meeting, somebody else is here, but we've done a good job as a group.
Okay.
Yeah, very seldom all 9 members are here.
That's what I'm saying.
All right.
Trying to think if I've ever attended a meeting with 9.
I know.
So I'm going to counterpoint that because when we moved from 9 to 7 with the Planning Commission, the same argument was made. And the counter argument is if there's fewer members on the board, the likelihood that those members will show up because they know nobody else is going to be there is much higher. And so far, we've never had a problem getting a quorum at the Planning Commission with 7.
Is the quorum still 5?
No, the quorum would then be 4 with 7.
One more than 50%.
Yep. So give that some thought. Because the Planning Commission was 9 members, but 2 of them were county commissioners. So when we moved to the 7, we took a county commissioner off. So we were only down 1 at large, essentially. This one, we would be down 2 at large because we only have 1 county commissioner. So give that some thought. I'm going to throw that one out there for you to noodle. So the next one was 3.03. So that's back where we were talking before. And when you look at 3.03, the title is Application for Drainage Permit, and it's been suggested to delete the D. Let's see. Let me look at this on here
Yeah,
to
there's
make
a
sure I
number
get
of,
the right ones. Oh, shoot.
Requirements there that I think we can eliminate, quite frankly.
303.
Just a second,
In
yeah.
303.
303.
Whoops, I went the wrong way.
Gary, do we require 811 be called when you issue a building permit?
Yeah, 811s are required, yeah, anytime there's.
But do you require it, that they prove that they called 811?
Well, state, no.
Right,
You don't
right,
ask for the,
right.
it's a state requirement.
That's why,
that
yeah,
they call
that's why
811.
I wonder if we couldn't take that out of here. We've never required it.
Yeah, but I think it's good to have it stated in there so people read it. You know, there's some people that,
I
Forget
don't
about
think, I don't think anybody's reading it, quite frankly, but.
oh, I call 811 every time we do.
Oh, yeah, I'm not saying that people don't do it.
But-
We're saying it's required before they get the application. And I don't know how you do that.
Yeah, it's a little different in a field than it is, you know, on a residential lot and stuff where there's construction going on.
The contractor is
But you
responsible
never
for
know.
doing it.
There are water lines and things that run through fields, so.
Mhm.
And now Vass has put fiber optic up.
Yeah.
I got a new line that runs through mine, and I come home that night from work and then I went, oh crap,
Okay.
They ran through my tile line that's by my house, 3 places. Yeah.
So let's see, it would be, in blue it's C, identification of sub-watersheds to be affected using best available data, which shall be deemed to include the Yankton County hydrology map, as well as any other data which identifies watershed boundaries, provided the source of such info is noted. Is that applicable?
Only time I seen a hydrology map was Chris Nelson brought it.
Yeah, we've never required it.
Well, the thing is they brought it to defend their map, or
Yeah, but
They brought it as their,
part of their findings of fact.
right, to verify.
to verify.
Mm-hmm.
Well, when you get into that, if I'm listening right. Okay, we got the Turkey Valley ditch up there. So now somebody pipes in water from, that's normally not into the only ones currently paying for the maintenance of the ditch are those that are attached to the ditch. So now, a few years back, Charles Olson wanted to tile. He tiled, come down, hooked onto Merlin Peterson's tile, which Merlin was agreeable, you know. But now Charles is putting X amount of acres, so he became attached to our Turkey Valley ditch. So that acreage gets taxed for maintenance on our ditch. So that's where your notification of watersheds or you know, Volun Lateral 1 or Turkey Valley ditch or whatever other ones are out there.
That's why that got put in there.
Yeah.
Okay, so we need to keep it.
Yeah, I would say.
I'd say we need to keep it.
It's
for the
not
water.
always applicable, but it's,
Still, especially when you get over east of town where all the
Okay.
ditches are.
all right. And then we decided we're gonna keep the 811, all signed waivers, including a complete 811 call notification.
How about D? After tonight's controversy,
Well, I'm assuming we don't want to delete it.
Leave it in.
Which one?
Vested
vested.
rights or the DNR or NRCS.
And the road authority, it's been proposed to change the wording there a little bit to say, any application for any drainage into a road right of way must include the written approval of the local road authority, not necessarily the county commission. So essentially Mike Solacek
So
could give
Mike
authority
can sign off. And
Mike
the
would be able
township
to-
board can sign off.
and the
That's what-
township board.
That way you don't have to have it come in here all the time. I'm all right with that.
So,
Why do we require certified drainage systems and referenced wetland maps
I was just gonna ask that same question.
where are you at, Kevin?
back on D?
D.
My only issue with that is, and we've talked about this before when we started the ordinance, but a wetland map shouldn't mean anything to this board. Because if the person wants to tile it and drain it, that's their right. The wetland is in RCS only.
Yeah,
And it affects their ability on their farm programs.
federal guidelines.
So
But
you're,
that's only.
so basically I'd say from the N reference wetland map were applicable, cross a line through there.
Because if they don't come here with a wetland map, it
It doesn't matter to us because you can drop out of the farm program.
I think what they're, but most people are using that map as to show where their lines are.
which is okay.
And
Yeah.
That's
works good for that, and I just always assumed, I guess, that's why it was requested, is so that
Because-
they have a map to draw their lines on.
Well, at one time there was talk of the board thought they should have wetland maps.
Yeah.
But at that time we debated about it, and I know it was like, that's not our responsibility,
No, I
and it doesn't
agree.
matter.
I think that's what it's used for most of the time, just to show that their lines don't go to the wetlands and stuff,
Right.
but
sometimes they need that for.
Certainly would save
episode.
time, because I know a lot of people that stalls them for a while, just take.
So this,
time to-
I think we just
Right.
cross out the and reference wetland map.
Because if they violate a wetland,
That's a federal.
that's a federal, and that's nothing that we deal with here. That would be between them and.
So we just say South Dakota vested drainage records and that's it? Is that what you're saying?
Or a copy of, see, why I also thought we had, when we talked about this, some of them are copy vested and some of them are recorded at the NRCS back in the 80s and 90s. We didn't record them here at the courthouse. We just recorded them at the NRCS office. And that's where we're
Yeah, we
at.
have vested ditches, and we also have ditches that are.
Are just NRCS.
Recorded at NRCS.
Yeah,
Okay,
But that doesn't affect subsurface drainage, what we're doing.
right.
Either one of them should really.
Well, if we
Only the,
could prove, yeah.
Yeah, vested drainage rights really shouldn't even come into play. It's just a recording of where an existing ditch is at. No
Well,
different
it
than
could be
any
a
other
vest-
natural
It
ditch.
could be a vested tile line, like Sternhagen's.
Could be. Mhm. Then
Yeah.
it comes into play. of
Then it
course.
comes into play.
And that would be part of the findings of fact.
Yeah.
Their argument that they should be approved for the
I
application.
think it can be left, but I just think if somebody does not have a wetland map, that shouldn't.
Oh, I think wetland should be taken out, yes. Mhm. I'm questioning even the vested drainage records. I guess we've never required it. It's never been part of an application.
okay. So that took care of that one. 3.04. And the title of this is notification to other parties, but if you look at number 2 and number 3, it says a signed statement from the applicant and contractor acknowledging each party understands the proposed project, the drainage ordinance, and zoning regulations. That technically should be in the previous section as part of the application.
So you're saying that should be 3.03.
Yes, and
I
then.
have no problem moving.
Number 3, the drainage administrator may also request that the applicant provide a detailed survey prepared by a professional engineer. That should technically be in 3.03 as
Go
well,
ahead and move them up. That's my feeling.
because it has nothing to do with notification.
Right.
So I will add those in the list that we just got done going through. 03, move. And then 3.07. Do we do emergency drainage? Have we ever done one?
I guess we haven't.
So the question was, do we do this? And if we don't ever do this,
That's
should it be?
Drainage board, though. Not drainage commission.
Mhm.
I have did emergency drainage to the drainage board many times in the past.
Have ya?
myself.
Okay, all right,
When
so,
it's flooding years,
okay,
they come in a lot.
gotcha, Gary.
They have in the past. I don't know
And that would
if
be
you
something the
did.
county, Yankton
That was.
County.
All right, and so I think that was all the comments I got from someone on that. Now, the fees in this, and I did look up in state law, they've not changed it. The maximum fee we can charge is $100. And under the fees, we have 2 separate fees depending on if it's administrative or whatever. I'm a proponent just have a flat $100 fee no matter what you need. Especially if we're gonna be doing the notifications ourselves, the county is, so I'll probably look at changing that, and that's limited. We can't charge anyone $1,000. Any other comments, as you guys have more experience with this than I do?
And I don't know where it's at in the ordinance or how it's written, but in the situation that we just had with a modified permit, shouldn't there be another permit issued with the modification on it? So that it's clear what it is. I mean, I
That
don't,
was what was asked, but we did put one, I did put one in the file, and John did ask about that, and we provided a copy. We provided a copy to him. So, yeah, we provided a copy to a public.
I mean, even
Okay.
even typically with the planning, if you're just asking for a modification of a portion of something, you don't necessarily have to reissue.
No.
Wouldn't it be like amendment?
It's just a part of the packet that,
Yeah,
that you have all that information in there for the file.
and it is, it's just an amendment to the original permit. Because you're just changing a section of what was originally granted.
Okay, cool, great.
Okay, any
It's
other
9:15.
comments?
I got a question. Okay, you know, up my Turkey Valley ditch thing, I'm seeking advice how to proceed. Okay, most of you, maybe Sherry don't remember this, but I had my neighbor tile and then it ran down on me and I was running across my field to get to the big Turkey Valley ditch. Well, last year got dry enough and I got all the approvals and Gary and I did a permit to run a solid pipe through my grassland to deliver that water into the Turkey Valley ditch. Now, if the water comes out of his pipe, goes through the township culvert, there's my pipe to pick it up with a pretty yellow dome. Now, is he attached to our ditch so I can go in and tax his butt to the ditch?
Oh.
That sounds like your board has to decide that.
Well, I was seeking advice.
That's your Turkey Valley board's gotta decide that one.
You know, because he's not directly, the two pipes are not directly tied to each other.
Defer.
I mean, if he wasn't part of that original district, it makes it tough.
Where's the water end up though?
In the ditch.
It
In
ends
the
up
ditch.
down in Vermillion.
Well, is it going into the
It goes-
district? Coming into the district and running down
It was running across my field,
yeah.
Okay.
But it ends up in your
in the ditch.
ditch, which ends up,
Surface runoff would have gone to the Turkey Valley ditch.
yes,
Yeah,
yeah.
'cause
long
as you
water-
know, when
if
you
the
set up
water's going
districts,
there,
generally you
that's
have all the parcels that are included in that can be taxed. So anything outside of that would be outside
Well,
of the
see-
original agreement.
This is why we're trying to develop a watershed,
Right,
because that ditch was made and the only ones paying tax on it were the people whose land touched the ditch. Unless they did a physical hookup like
Sure.
Charles Olson did.
sure.
And we do have a couple of them. But, so I'm, just in case that we tabled due to COVID going forth with our watershed. But someday I'll be into the office, Gary, going, I need help with this watershed.
Yeah, we'll take a look at it.
You know, because there's, we had an engineer on the deal, or there's like currently 2,200 acres that pay for the maintenance, but there's like 6,400 acres that drain into the system by surface. And 2,600 of those 64 are in Turner County.
Not uncommon.
You know, so anyways,
Seeing it's 9:20, I take a motion for adjournment.
So moved.
All in favor, say
all right.
Aye.
all opposed.